Welcome to the Case Bank update for May 2020. 13 selected case holdings in under 7 minutes. Case 1. Immediately after the guilt verdict, defense counsel declares a 1368 doubt of defendant's competence. Jury is sent home for months while 1368 is resolved with a separate 1368 jury. After defendant found competent, penalty phase resumes. All upheld. Holding 2. Defense attorney testifies at the defendant's 1368 trial. The prosecutor, on cross, asks about possible tactical advantages the defendant would gain in the underlying case from a finding of being incompetent. Held, this is proper cross-examination on the subject of the defense attorney's motives for testifying. This was a death penalty case.
Holding 3. Minor goes on crime spree, including serious and violent felonies. Then the minor resists arrest. Held. If the misdemeanor 148 is charged, it becomes the last charged crime, and the defendant is therefore ineligible to be sent to CYA for Section 733C. Holding 4. In the Miranda context, no is ambiguous when it is in response to an ambiguous question. Officer was permitted to ask follow-up questions to clear up the ambiguity.
Holding 5. After the preliminary hearing, the defendant waived time for his arraignment, but was not asked to waive time for the filing of the information. The information was not filed until the day before the arraignment. Held. A separate waiver is required. The information was filed too late under PC 1382. Case dismissed.
Holding 6. The defendant writes a bizarre, delusional, wacky, threatening letter to the prosecutor handling his case, demanding that the case be dropped. Defendant convicted of PC 69. Conviction is reversed. DCA concludes that the letter was not a serious expression of intent to commit an act of unlawful violence. Holding 7. If the prosecutor knows her witness at the prelim will be likely deported before trial, she must 1. Tell defense attorney before the prelim. 2. Videotape the prelim. 3. Make a good faith effort to delay the prelim. 4. Be open to any other creative remedy. Due diligence after deportation is not enough.
Holding 8. The defendant has mental issues. Defendant clearly did not have the ability to represent herself effectively, but defendant did have the ability to make an intelligent waiver of her right to an attorney. Trial court denies Faretta request. It is reversed. Holding 9. During jury selection in a case from 1999, the prosecutor asked jurors if they were upset with the O.J. Simpson verdict. If they said they were not upset, the prosecutor preempted them. In this case, like O.J.'s, DNA was a crucial part of the case. Held, this was a racially neutral reason, even if more blacks than whites were not upset with the O.J. verdict.
Holding number 10. Defendant testifies that he did not do the crime, notwithstanding a taped confession. In closing argument, his attorney argues the defendant is guilty of a lesser. Defendant objects in open court and is ultimately removed from the courtroom. Defendant's conviction of the greater is upheld. Defendant did not tell his attorney before argument not to concede guilt to the lesser. Holding 11. The DA argued that prison guard witnesses would not, quote, put their entire careers on the line, unquote, by lying. Held. This is improper vouching based on facts not in the evidence. No evidence was presented that the guards would be fired if caught lying. Holding 12. What jurors say during voir dire is not evidence. Deputy DA referred to comments made by jurors, some on the final panel, some not, during closing argument. Held, this is misconduct, but harmless. Comments were used to make rhetorical points, not to show the defendant is guilty.
Holding 13. The jury got the standard CalCrim instructions regarding readbacks. During deliberations, the jury asked for a transcript of witness X. Court told the jury no transcripts and nothing else. Held. This was error. Court should have reminded the jury that readback of testimony was available. If you go to our website at casebanklaw.com, you will be able to download a PDF of all the case summaries entered during the month of May, or you can download the entire database, which consists of over 20,000 case summaries entered over the last 29 years. Thank you.